did mention the role of the courts, the Indian judiciary in the arbitration system. Do you think the Indian judiciary has finally struck a balance between judicial intervention and party autonomy, the autonomy of arbitration proceedings, which is one of the basic tenet of arbitrations? So do you think the court has struck a balance, or is there still some push and pull happening there?
Thank you, Steffi. Good afternoon, everyone. Namaste. Courts, I would say, play an extremely pivotal and decisive role in ensuring that this balance is struck. And how do they do that? Interference in only those matters which require an interference, and others following the mandate of the Act. The basic ground norm of arbitrations is autonomy, and its entire foundation rests on it. The Arbitration and Conciliation Act itself envisages a check and balance mechanism in relation to judicial interference in the form of Section 5 of the Act. And what does the section say? It says that notwithstanding anything contained in any other law for the time being in force, no court shall interfere except in relation to the situation specifically envisaged in the Act. So courts are expected to follow the mandate of Section 5. Looking at the trend of judicial decisions, and particularly from recent times, they are doing all possible to ensure that arbitrations get the place that they deserve. There are, Steffi, exceptions here and there, but those I would say are minor aberrations and certainly do not define the importance which our judiciary gives to arbitrations. If I could give a few examples, the Supreme Court in Videocon Industries versus Union of India reiterated Section 5 and said that no court shall interfere in any matter except in those specific situations. As to how a balance is struck, there is an insightful passage in one judgment of Surya Devi versus Ramchandra Rai. If I could read out for everybody's information. If a court intervenes in pending proceedings, there is bound to be a delay in termination of proceedings. If it does not intervene, the error of the moment may earn immunity from correction. Thus, the power is there, but the exercise is discretionary, which will be governed solely by the dictates of judicial conscience, enriched by judicial experience and practical wisdom of the judge. In a recent Supreme Court matter, Section 34 matter, very recent, 21st September 2023, Bartley Boy Engineers versus HPCL, Supreme Court has again reiterated that judicial interference is not meant to correct errors of fact or law, but judicial interference is needed where an award shocks the conscience of the court, in the sense that it is perverse and irrational, or it is whimsical. And those are the situations where, of course, interference is needed and must, by all means. But courts are not sitting there as a court of appeal. So every error of fact or law will not require an interference. And courts do understand this. In the opening remarks, we saw from some of our speakers that courts in Delhi, Supreme Court, Delhi High Court, Mumbai High Court, they're very proactive when it comes to rendering decisions, and they're very careful. They do not cross that Lakshman Rekha, if I may call it, and therefore courts are trying to maintain that balance. To conclude, it is safe to assume that yes, courts are striking that balance, they're interfering where an award shocks the conscience, it's perverse, whimsical, arbitrary, and they're not doing so where there is only an error of fact or a simple error of law.
Thank you, Siddharth. Very insightful. So one rapid fire question that I will ask to all the panelists, and feel free if you do not want to answer this question. We talk about India becoming a $10 trillion economy within the next 5 years, 10 years. For that, I think India should also become a hub for international arbitration. With the reforms for the Indian Arbitration Act still in process, what is that one expectation that you have from the new amendments that will come up very soon? One each. Rapid fire, let's keep it quick. Interesting. Siddharth, next to you.
So I have a fairly large wish list.
We keep it to one.
Yes, I'll keep it very short. So in June 2023, Ministry of Law and Justice has constituted a 16-member committee to look into the working of the arbitration law in India and the reforms that are needed in the Arbitration and Conciliation Act. So I have 10 points, but I'll take just 4, which are very close
We
to
keep
mine.
it to 1. You're really nearing the end of the
Okay,
session.
so provision for emergency arbitration is something, regulation of third-party funding, the confusion regarding enforceability of unstamped arbitration agreements. 3 days back, this issue has been referred to a 7-judge bench. My take is that in the Act itself, there should be some provisions that minor irregularities and errors which are curable should not affect the larger scheme of things if we really want to become a hub of institutional arbitration, and enforcement of emergency awards, which has been a bone of contention. Recently, we saw that in Amazon versus Future Retail. So those are the four key things that I.
Thank you, Siddharth.
With an interest limit of 4,000 crores. That's a kind of a massive scale. It's around 4,000 crores the company need to realize. But ultimately, after about 3 years of hard work and kind of a struggle, we had to discount it for 1750 crores. And ultimately 1750 crores is the one which is cash down on the table. And so one has to forego 4,000 crores to get a cash down of 750 crores. I mean, it makes a business sense whether you take 1750 or you wait for 4,000. That's completely the management prerogative. But having said that, the kind of a stiff opposition which we faced is not from the company and the board of directors. It's from the clientele. The clientele would not like to have this kind of a third-party funding, and no agreement would say about either a subrogation or the kind of any of these aspects, which can give the right, the claim accrual to somebody else in third party. I think that's where we have a very tight rope walking in terms of third-party funding. The wish list is very good, the intentions are good, but when you come to the practical sense, it becomes next to impossible because the clientele would not agree to have. Say, for example, in the contract, if you put a clause stating that it will go to a third-party funding and we have a right to have a subrogate to somebody else. If you put that, I think the contract will not be signed as such. So, Mr. Siddharth, the point here is that the committee which has been constituted to focus upon the India making it as a global up for the arbitration, I think in all earnest, it should consider the clauses that are required to be packed in so that the arbitration becomes the one and then it becomes integral to India becoming a kind of hub. Is there any thinking in that process to make these things integrated, the contractual as well as the arbitration being the hub? That's the question.
So the 16-member committee that has been constituted has some very big names from the arbitration fraternity who have faced these challenges and who are aware of all these problems. And this issue is certainly on the table. I had a discussion with one senior counsel who's also a part of that committee, and this aspect is being looked into. And therefore, when I say the need for regulation of third-party funding, wish list, of course, but it's not without reason. It's a facet of access to justice. Here you spoke about a big company which was looking at a claim running into several thousands of crores. But when we are looking at it, all kinds of users. A person may have the most meritorious claim, but may not have the wherewithal to contest it or to fight with the might of a big organization. So in that context, when the government and the committee is suggesting the changes, they are keeping into mind not these big corporations. Of course, that aspect is also being looked into, but they are also looking at it from the context of someone who may not have the might to fight a big corporation. Access to justice. In fact, the Delhi High Court matter which Mohit mentioned, I'll read that passage out to you and it's very insightful. It's a judgment of Delhi High Court in Tomorrow Sales Agency versus SBS Holdings. I have that passage here with me, where the Delhi High Court says, we are unable to accept the said view, and the said view being that third-party funding not being allowed. Third-party funding is essential to ensure access to justice. In absence of third-party funding, a person having a valid claim would be unable to pursue the same for recovery of amounts that may be legitimately due. In many cases, the claimants become impecunious, and on account of the very cause for which they seek redressal. The cost of pursuing claims in arbitration are significant. The same not only include fees paid to arbitrators, institutions, but also professional fees for legal counsels and experts and other attendant expenses. A person without the necessary means would have no recourse.
in the absence of third-party funders. Third-party funders play a vital role in ensuring access to justice. And therefore, Mohit sitting here, we must thank him. You're going to play a key role in ensuring access to justice, which is very important.
Thank you, Siddharth. With that, I give it up a huge round of applause for all our panelists here.